Hi, I'm Saeed, Los Angeles domestic violence attorney, and welcome to CBS Law, where we deliver results, not promises. I want to talk to you today about domestic violence cases. First, I'll talk about the two most common domestic violence charges. Second, I'll go over some defenses we successfully employ every day in domestic violence cases. And third, I'll go over some common sense measures you can take if you or a loved one find yourself arrested for or being investigated for a charge of domestic violence. Far and away, the most common domestic violence charge is a violation of Penal Code Section 273.5. This crime can be charged as a misdemeanor or as a felony. More on that in a second. First, let's talk about what constitutes a violation of Penal Code Section 273.5. First, that you touch someone that you're in a relationship with or had been in a relationship with in a harmful manner without their consent, resulting in something called a traumatic condition, which basically just means a wound or an injury. Now, the determining factors for the prosecution when deciding whether the charges are a misdemeanor or a felony are two. First, what is the extent of the injuries? If we're talking redness or some swelling, that's going to move this more towards the misdemeanor side of the ledger. On the other hand, if there are broken bones, stitches, loss of consciousness, loss of organ function, or disfigurement, that's going to push this more towards the felony side of the ledger. The second factor that the prosecution is going to look at in determining whether to file this as a felony or a misdemeanor is your criminal history. If you have no prior criminal history, that's going to push it more towards the misdemeanor side. On the other hand, if you have multiple convictions for domestic violence or any other violent acts, that's going to move it more towards the felony side. Now, a little known fact. Every time the police make an arrest for a violation of Penal Code Section 273.5, they're going to classify it as a felony. But remember, the police don't charge you with the crime. The prosecution does. The police just classify the arrest. The reason they always classify these arrests as felonies is because of something called stat inflation. Basically, at the end of the year, the police agency wants to be able to say, we made 10,000 felony arrests, because it just sounds more important and better than saying they made 3,000 felony arrests and 7,000 misdemeanor arrests. The consequences for a violation of Penal Code 273.5, if it's charged as a felony, you're looking at up to 4 years in state prison, servable at halftime. That means the most you can do is half of the time the judge sentences you to. If it's charged as a misdemeanor, the most you're looking at is 364 days in the local county jail, again at halftime. The second most common charge in domestic violence cases is a violation of Penal Code Section 243, subdivision E1. That can only be charged as a misdemeanor. It can't be charged as a felony. What constitutes a violation of this charge versus the first one? Well, they're similar. It involves you touching someone that you're in a relationship with or had been in a relationship with in a harmful or offensive manner without their consent. There's no requirement of a traumatic condition or injury. As this can only be charged as a misdemeanor, the most you're potentially facing is, again, 364 days in county jail at halftime. I want to talk to you now about some of the most common defenses we pursue in these cases. Far and away, the most common is self-defense. Self-defense has 3 elements under the law. Let me explain. First, did you reasonably believe that you were under immediate threat of an unlawful touching or harm? Second, did you reasonably believe that force was necessary to deter that immediate threat of an unlawful touching or harm? And third, did you use no more force than was necessary to deter that threat? An example of that third factor would be if someone pushes you and you push them back, fair game. But if someone pushes you and you seriously injure them with like a knife or a other weapon, well, that may not be proportional or a reasonable amount of force to deter that threat. Second, that it just didn't happen. That is a common defense that we pursue, especially in Penal Code Section 243E1 cases where there is no injury. Oftentimes, domestic violence cases only involve two witnesses, the victim and the suspect. In other words, there's no independent third-party witness to say, hey, I saw what happened and I can verify what he said or she said is accurate. And what we find in these cases, especially in domestic violence, is oftentimes there are other family issues at play that will tend to doubt the credibility of the accusation being made. Let me explain. Often we find there's issues of infidelity, child custody issues, financial stress, drug or alcohol use, or other family issues that's going to affect the believability of the accusation made. What I'd like to do now is talk about some common sense measures you can take if you find yourself arrested or being investigated for a domestic violence case. First, if you have any injuries whatsoever, you need to document those injuries. Ask the police to photograph your injuries. Whether the police do so or not, even if they do, when you have your first opportunity, take photographs of your injuries to document what happened to you. Similarly, if you have injuries, go get medical care. Later on, we can get those medical records to substantiate that you were acting in self-defense. But far and away, the worst mistake you can make is to wait. And what I mean by that is, I can assure you, the prosecution is working on you or your loved one's case right now, and we need to get started on yours. So call CBS Law now at 213-800-8005, and together we'll get your life back.